From binary code to legal program simulation, towards a mathematical model of legal intelligence. Abstract. Legal reasoning is usually described as the application of law to facts, producing a binary outcome, legal or illegal. This paper argues that the binary distinction describes only the final compression of a much longer cognitive process. Before conduct can be marked as lawful or unlawful, a factual event must first be transformed into a legal event through the selection of a legal program. Building on Niklas Luhmann's distinction between legal code and legal programs, this paper develops a mathematical model of legal intelligence. It introduces the zero-state, legal interpretation, legal valence, competing program systems, and the judicial function as elements of a broader computational architecture of legal reasoning. The central claim is that legal expertise begins before legal rules are applied. It begins with identifying which legal program has interpretive competence over a factual event. On this model, artificial intelligence should not be understood primarily as a tool for legal document generation, but as a means of simulating, comparing, and testing legal programs. The future of legal AI may therefore lie not in faster drafting, but in legal program simulation, the computational exploration of how reality becomes capable of receiving legal meaning. 1. The classical binary model. The starting point of this inquiry is not artificial intelligence, but a much older question arising from systems theory. Niklas Luhmann famously described law as operating through a binary distinction: legal, illegal, legal, illegal, legal, illegal. Within systems theory, this distinction is referred to as the legal code. For the purposes of this paper, however, it is useful to distinguish between the sociological meaning of code and its computational meaning. In Luhmann's theory, the code functions as the binary distinction through which the legal system communicates. In computational architecture, however, a code normally refers to something different, a structured sequence of executable operations capable of transforming an input into an output. The binary distinction, legal, illegal, legal, illegal, legal, illegal, does not itself perform such a transformation. It merely represents the possible end states of legal classification. This distinction becomes important because it changes the question we are trying to answer, rather than asking. How does law distinguish between legal and illegal? We ask a computational question. How does reality become capable of receiving either of these values? Suppose that an event is represented simply as E. The classical binary model implicitly assumes that legal reasoning consists of assigning one of two possible values: E1 plus E (1) plus E plus 1, or E1 E 1 E minus 1, where plus 1 equal to legal, plus 1 equal to legal, plus 1 equal to legal, minus 1 equal to illegal, minus 1 equal to illegal, minus 1 equal to illegal. At first sight, the model appears complete, yet it immediately encounters an anomaly. Consider the following event. Equal to a person is sitting on a bench. Equal to text, a person is sitting on a bench. Equal to a person is sitting on a bench. Before any legal reasoning begins, the event cannot meaningfully be assigned either value. It is not legal, it is not illegal. More precisely, neither proposition has yet become computable. This immediately creates a mathematical problem. If the binary model allows only two possible values, minus 1 plus 1, minus 1 plus 1, minus 1 plus 1, this, no valid position within the model. The model therefore appears complete only because it begins after the decisive computational step has already occurred. The obvious question is therefore not whether legal reasoning is binary. The question is whether binary reasoning presupposes an earlier state that has never been explicitly modeled. 2. The first variable, the event. Having established that the binary distinction describes only the final state of legal classification, the next question is more elementary. What exactly is it that law classifies? The obvious answer might be facts. But facts do not arrive inside law already bearing legal meaning. Before a legal program is selected, even a factually dense situation may remain legally unmarked. Consider the following factual event. A civilian solicitor attends the controlled entrance area of a military site in her professional capacity. On a previous occasion, in materially similar circumstances, she had been present in the same type of controlled area as a solicitor, without any personal restriction being applied to her. On the later occasion, security personnel refuse to allow her to remain or proceed. They do not provide a written decision. They do not identify the legal basis of any personal restriction. They do not explain whether the refusal is temporary, security-based, administrative, procedural, or connected to any adverse marker in a security system. During the interaction with military police, the solicitor asks for an explanation. She asserts that, as a British citizen, she is entitled to know whether any decision has been made affecting her status, access, or treatment. The military police respond that she has no rights as a citizen. The solicitor remains in the controlled area and continues to ask what decision has been made about her and on what basis. Military police then treat her continued presence as non-compliance with site security instructions. They brief civilian police that she is under investigation and that her conduct concerns alleged breach of national security legislation, including the National Security Act and/or the Official Secrets Act. Civilian police attend and inform the solicitor that the matter concerns national security legislation, espionage, and alleged breach of the Official Secrets Act, National Security Act. At no point has the solicitor been given any prior notice of an adverse status, personal restriction, security marker, or decision prohibiting her presence. This is not a simple factual scene. It is dense with institutional conduct, legal language, security signaling, and competing claims of status. Yet it is still not legally classified. Let us define E equal to event, more precisely, E equal to E1, E2, E3, E11, where E1 equal to civilian solicitor attends controlled site entrance in professional capacity. E2 equal to previous comparable professional attendance occurred without restriction. E3 equal to continued presence is refused. E4 equal to no clear decision, notice, or legal basis is provided. E5 equal to solicitor requests explanation of any decision affecting her status. E6 equal to solicitor asserts citizen-based entitlement to know the decision. E7 equal to military police state that she has no rights as a citizen. E8 equal to military police treat continued presence as security non-compliance. E9 equal to military police investigation. E10 equal to national security legislation is invoked, including the National Security Act and/or Official Secrets Act. E11 equal to no prior notice of any adverse status, restriction, marker, or prohibitory decision has ever been given. At this stage, the event clearly exists, but its legal value has not yet been generated, so the only honest notation is LE equal to. The question mark matters. It does not mean that the event is neutral in the sense of being legally approved. Nor does it mean that the competing legal forces are perfectly balanced. It means something more basic. No legal program has yet been selected that can transform the factual event into a legal event. The event is factually dense but legally unmarked. Through one legal program, it may appear as a site security incident. Through another, it may appear as enforcement of an unnotified personal restriction. Through another, it may appear as a public law failure of notice, reason, status, and legality. Through another, it may raise questions of differential treatment. Through many other legal programs, it may produce no legal meaning at all. The mathematical problem is therefore not yet LE greater than 0 or LE less than 0. The first problem is LE equal to. This is where the binary model begins to fail. It can describe the final polarity of legal meaning, but it cannot yet explain how a factual event becomes capable of receiving that polarity. Not yet explain how a factual event becomes capable of receiving that polarity. 3. The missing variables. The previous section established an important result. A factual event can exist in considerable detail without yet possessing any computable legal value. The notation, LE equal to, therefore represents more than uncertainty. It represents an incomplete model. The immediate mathematical question becomes, how does a factual event become capable of legal evaluation? The classical binary model offers no intermediate operation. It assumes that an event can be classified directly as legal or illegal, yet the example above demonstrates that this assumption cannot be correct. The factual event remains identical. Nothing about the observable reality changes. Nevertheless, lawyers, judges, regulators, and public authorities may reach entirely different legal conclusions. If the event itself remains constant, then the source of variation must lie elsewhere. The model therefore requires additional variables. The first is the legal program. Let P equal to legal program. A legal program is a coherent interpretive framework through which the legal system processes a factual event. Examples include public law, national security law, equality law, contract law, company law. The legal program does not alter the factual event. It alters the questions that are asked about the event. It determines which facts become legally relevant, which are ignored, which legal principles are activated, and which normative objectives guide the analysis. The second variable is therefore required. I equal to legal interpretation. Legal interpretation is not the event itself. It is the meaning generated when a factual event is processed through a particular legal program. At this stage, the relationship can be expressed simply as E plus P, I. The factual event enters the legal program. The program produces an interpretation. Importantly, the same event may generate multiple interpretations if different legal programs are selected. The third variable naturally follows. Let L equal to legal valence. Legal valence represents the legal direction produced by the interpretation. At this stage of the analysis, it is not yet necessary to define how legal valence is calculated. It is sufficient to recognize that legal valence cannot arise directly from the event itself. It arises only after the event has been interpreted through a particular legal program. The developing model can therefore be expressed as E, P, I, L. This sequence is significantly different from the classical binary model. The binary distinction between legal and illegal no longer appears as the starting point of legal reasoning. Instead, it becomes the final stage of a much longer computational process. The remainder of this paper is concerned with understanding how that process operates. 4. Legal interpretation. The introduction of the legal program immediately changes the nature of the problem. The event itself has not changed. The legal program has. This raises an obvious question. What exactly does a legal program do? It does not create new facts. It does not alter reality. It does not change the chronological sequence of events. Instead, it performs something far more fundamental. It transforms a factual event into a legally meaningful representation of that event. This transformation is what this paper refers to as legal interpretation. Let I equal to legal interpretation. Legal interpretation should therefore not be understood as a subjective opinion or judicial discretion. It is the computational output produced when a factual event is processed through a particular legal program. The relationship may therefore be expressed as I equal to FP, E, where E equal to factual event, P equal to selected legal program, I equal to legal interpretation. The notation is important. The function does not generate a new event, nor does it alter the existing one. Instead, it generates a new representation of the same event. The physical reality remains constant. Its legal representation changes. This distinction explains why different legal programs produce different legal interpretations without requiring any disagreement about the underlying facts. For example, consider the event described in the previous section. A national security program may generate the following interpretation. The solicitor remained within a controlled security area after being instructed to leave and therefore failed to comply with site security measures. A public law program may generate a different interpretation. A public authority enforced an undisclosed administrative restriction without prior notification, reasons, or procedural fairness. An equality law program may produce yet another interpretation. The factual sequence raises the possibility of differential treatment requiring legal justification. A company law program may generate no interpretation of legal significance at all. The factual event has remained identical throughout. Only the interpretive function has changed. This observation has an important consequence. Legal disagreement is often described as disagreement about law or disagreement about facts. The present model suggests a different possibility. Very often, legal disagreement begins much earlier. It begins with the selection of the interpretive function itself. Different legal programs do not merely produce different legal conclusions. They produce different legal realities. The event remains constant. The legal world constructed around that event does not. 5. Legal valence. The introduction of legal interpretation immediately raises another question. If different legal programs generate different interpretations of the same factual event, how should those interpretations be evaluated? Interpretation alone cannot produce a legal conclusion. A further operation is required. Let L equal to legal valence. Legal valence represents the legal direction generated by a particular interpretation. Importantly, legal valence should not be understood as a binary label attached to an event. It is a property of the interpretation generated by a particular legal program. Different legal programs applied to the same event may therefore generate different legal valences. The present model proposes that legal valence should be understood as a continuous variable rather than an immediate binary outcome. Conceptually, L greater than 0 indicates that the interpretation tends towards legal justification. L less than 0 indicates that the interpretation tends towards legal unlawfulness. L equal to 0 does not mean that the conduct is lawful, nor does it necessarily mean that the conduct is unlawful. It means that the selected legal program has generated no meaningful legal valence with respect to the event. In other words, the program lacks interpretive competence for the question under consideration. This distinction has an important mathematical consequence. Legal reasoning is no longer understood as the direct classification of facts. Instead, it becomes the evaluation of competing legal valences generated by competing legal programs. The event itself remains constant. Only the legal program changes, the interpretation changes, the legal valence changes. Consequently, legal outcomes change. This observation suggests that legal disagreement is fundamentally a problem of competing interpretive architectures rather than competing factual realities. It also has an important computational implication. If legal valence is generated by the selection of a legal program, then choosing the program is not merely a preliminary step in legal reasoning. It becomes one of the principal determinants of the legal outcome itself. The practical implications of this proposition extend well beyond legal theory and will be explored separately. For present purposes, it is sufficient to observe that the mathematical structure of the model assigns explanatory significance not only to legal interpretation, but also to program selection itself. 6. The discovery of zero. The preceding analysis allows us to return to the zero state with greater precision. At the beginning of the model, zero appeared as a pre-legal condition, the state in which an event exists before any legal program has generated legal value. We can now refine that idea. Zero is not merely the absence of legal meaning. It is also the point from which the relevance of competing legal programs can be tested. Consider again the same factual event. A solicitor remains in a controlled area of a military site after asking to be told the basis of a restriction applied to her. If this event is processed through company law, the result is not that the solicitor's conduct becomes lawful. The result is simply zero. Company law has no interpretive competence over this event. The same would be true of many other legal programs. Intellectual property law, corporate finance, maritime insurance, or shareholder remedies may all be sophisticated legal programs, but they do not generate legal valence in relation to this event. They return L equal to 0. This matters because it shows that program selection is not merely a matter of preference or advocacy. It is a test of interpretive competence. For any given event, most legal programs will produce 0. They do not fail because they reach the wrong answer. They fail because they cannot generate a meaningful legal question. This gives 0 a second function. It is not only the initial state before legal interpretation. It is also the neutral testing point to which legal reasoning may need to return when competing programs are advanced. In litigation or institutional dispute, each party often attempts to pull the event into its own legal program. One party may say, P1 equal to national security program. The other may say, P2 equal to public law program. The question is not immediately which party is right. The prior question is, which program has interpretive competence over the legal question actually being asked? To answer that question, the analysis must return to 0. At 0, the event is stripped back to its factual form before either party's program is allowed to dominate it. From that point, each proposed program must justify its relevance. Does the national security program explain the issue before the court? Does the public law program explain it? Does the equality program explain it? Does any other program generate legal valence? This return to 0 performs an important cognitive function. It prevents one party's legal program from becoming the unquestioned reality of the dispute. It allows the analyst to ask, is the opponent's program actually applicable, or has it merely captured the language of the dispute? In this sense, zero is not passive. Zero is a method of legal cleansing. It clears away premature legal meaning so that program relevance can be tested again. The practical structure is therefore, event, return to zero, test program relevance, identify program with interpretive competence, generate legal interpretation, generate legal valence. This explains why a powerful legal strategy may depend not on defeating the opponent's argument inside the opponent's program, but on showing that the opponent's program does not answer the relevant legal question. The program is not necessarily false. It may simply be irrelevant. It returns L equal to zero. The discovery of zero therefore changes the function of legal reasoning. Zero is not a void. It is the neutral point from which competing legal programs can be tested, excluded, or re-entered. It is the point at which law asks, before asking what is legal or illegal, what program is competent to interpret this event. 7. The function of the lawyer. This model leads to a different understanding of legal expertise. If legal reasoning begins with program selection, then the lawyer's primary function is not simply to know rules or generate legal answers. The lawyer functions as an architect of legal programs. More precisely, the lawyer identifies, constructs, tests, and maintains the legal program through which a factual event is to be processed. This involves several operations. First, the lawyer must identify which legal programs possess interpretive competence over the event. Most candidate programs will return zero. They can be discarded. Second, the lawyer must construct the selected program with sufficient precision. This means identifying the relevant legal principles, factual predicates, evidential requirements, procedural constraints, and remedies. Third, the lawyer must test the program for internal coherence. A legal program can contain errors. It can rely on the wrong facts. It can assume the wrong legal question. It can confuse evidence with inference, procedure with remedy, security language with legality, or institutional assertion with legal authority. In that sense, the lawyer is not only an advocate, the lawyer is also a debugger of legal reasoning. The program must be cleaned of conceptual bugs before it is allowed to generate legal valence. This process is not a one-off exercise. In institutional disputes, the legal program must be continuously maintained. Institutions rarely respond to a legal claim by accepting the claimant's program of interpretation. They often attempt to reframe the event through their own program. A public authority may convert a question of notice into a question of security. A procedural challenge may be reframed as operational necessity. A request for reasons may be reframed as inappropriate curiosity. A claim about status may be reframed as a demand for access. This is not merely rhetorical. It is program contamination. The opposing institution attempts to insert its own assumptions, categories, and priorities into the claimant's legal program. If successful, the original program begins to produce distorted outputs. The lawyer's task is therefore continuous. The lawyer must preserve the integrity of the selected program. The lawyer must identify attempted reframings. The lawyer must remove foreign assumptions. The lawyer must return to zero when necessary and ask again, what is the actual legal question? Which program has interpretive competence over it? Which facts belong to that program? Which facts are being imported from an opponent's program? On this model, legal expertise is not rule retrieval, it is program architecture. The lawyer is paid not merely to know law, but to design and maintain the legal architecture through which reality becomes legally intelligible. 8. Competing legal programs. The preceding sections considered the legal program as if only one program were being applied. In real legal disputes, this is rarely the case. The same factual event may be processed through multiple competing legal programs at the same time. A claimant may select one program. A defendant may select another. An institution may attempt to impose a third. The court may ultimately accept, reject, or modify any of them. The model must therefore move from a single interpretive sequence to a system of competing sequences. Let EC equal to the event as advanced by the claimant. ED equal to the event as advanced by the defendant. PC equal to the claimant's selected legal program. PD equal to the defendant's selected legal program. IC equal to the claimant's legal interpretation. ID equal to the defendant's legal interpretation. LC equal to the claimant's legal valence. LD equal to the defendant's legal valence. At first sight, the parties may appear to be arguing about the same event. But in litigation, the event is rarely identical on both sides. The claimant selects, orders, and emphasizes facts in one way. The defendant selects, orders, and emphasizes facts in another. The dispute therefore begins not with one event, but with two event forms, e.c. not equal to ed, even where both are derived from the same underlying factual reality. Each side then applies its own legal program. For the claimant, EC plus PC, IC, LC. For the defendant, ed plus PD, ID, LD. This produces two competing interpretive chains. Claimant chain, EC, PC, IC, LC. Defendant chain, ed, PD, ID, LD. Legal dispute can therefore be represented not as a simple disagreement about the final answer, but as a conflict between two legal program systems. The claimant does not merely say, "The defendant's conduct was unlawful." The claimant says, "When the event is processed through this legal program, it generates a negative legal valence for the defendant's conduct." The defendant does not merely say, "The conduct was lawful." The defendant says, "When the event is processed through a different legal program, it generates a positive legal valence for the defendant's conduct." The court is then faced with a higher order question. It must not only decide which conclusion is correct, it must decide which interpretive chain has legal authority. In other words, the court compares LC equal to legal valence generated by claimant program with LD equal to legal valence generated by defendant program. But that comparison cannot be made only at the level of outcome. The court must also consider 1. Whether EC or ED is better supported by evidence. 2. Whether PC or PD possesses interpretive competence over the question before the court. 3. Whether IC or ID follows coherently from the selected program. 4. Whether either program imports irrelevant assumptions from a different legal reality. 5. Whether either program returns zero in relation to the actual legal question. This is why legal disagreement often appears to be about facts but is actually about program selection. Two parties may agree on much of the factual reality, yet disagree completely because they are running different legal programs over that reality. A national security program may produce one interpretation, a public law program may produce another, an equality law program may produce a third. Each program creates a different legal representation of the same underlying reality. At this point, the model can be expressed as a system. Claimant, EC plus PC, IC, LC. Defendant, ED plus PD, ID, LD. Court. Compare EC, PC, IC, LC with ED, PD, ID, LD. This is the adversarial architecture of legal reasoning. Legal reasoning is not only the application of law to facts, it is the comparison of competing event forms, competing programs, competing interpretations, and competing valences. The decisive question may therefore be not which side has the better answer, but which side has selected the program competent to interpret the event before the court. 9. The judicial function. The preceding section described litigation as a conflict between competing legal program systems. The claimant advances one event form, one legal program, one interpretation, and one resulting legal valence. The defendant advances another. The judicial function must now be introduced. Let J equal to judicial function. The judicial function is often described as deciding whether conduct is lawful or unlawful. That description is incomplete. By the time a dispute reaches the court, both parties have usually already generated their own legal valence. The claimant's position has produced one valence. The defendant's position has produced another. The court is therefore not simply applying law to facts in the abstract. It is evaluating competing legal architectures. The structure may be represented as follows. Claimant, EC plus PC, IC, LC. Defendant, ED plus PD, ID, LD. Judicial function, JEC, PC, IC, LC, ED, PD, ID, LD. Decision. The court's task is not only to compare final conclusions. It must examine the whole chain. It must ask, is the claimant's event form supported by evidence? Is the defendant's event form supported by evidence? Does the claimant's legal program possess interpretive competence over the issue before the court? Does the defendant's legal program possess interpretive competence? Does the interpretation follow coherently from the program? Does the resulting legal valence answer the actual legal question? This means that judicial decision-making is not merely a choice between legal and illegal. It is a higher-order comparison between competing systems of legal meaning. The court may find that one program produces stronger legal valence than the other. It may find that both parties' positions have legal force. It may find that both are legally defective. It may also find that one party's program simply does not answer the legal question before the court, and therefore returns 0. This is where the choice of legal program becomes decisive. A party does not always need to defeat the opponent inside the opponent's program. Sometimes the more powerful move is to demonstrate that the opponent's program has no interpretive competence over the question to be decided. The famous prosecution of Al Capone illustrates this at a simplified level. The historical reality did not change. What changed was the legal program. Attempts to prosecute one type of conduct produced insufficient legal traction. A tax program produced a legally decisive event. The prosecution did not discover a new reality. It selected a different program through which reality became legally actionable. This distinction is central to the present model. There is a difference between a physical event and a legal event. A physical event exists in reality. A legal event is extracted from reality through a legal program. The judicial function is therefore not simply to observe reality and declare its legal status. It is to decide which proposed legal event, generated through which legal program, should be recognized as legally authoritative. In this sense, the court does not merely decide the answer. It decides which legal program is permitted to generate the answer. 10. Artificial intelligence and legal program simulation. The computational model proposed in this paper has implications extending well beyond legal theory. It also suggests a fundamentally different role for artificial intelligence. Most contemporary legal AI systems operate at the documentary layer of legal practice. They retrieve authorities, they summarize cases, they draft contracts, they generate pleadings, they assist legal research. Although these tasks are valuable, they all occur after a fundamental intellectual decision has already been made. The legal program has already been selected. The legal question has already been framed. The architecture of legal reasoning has already been determined. Current AI systems therefore optimize legal work inside an existing program. The present model suggests that the greater opportunity lies one computational layer earlier. Instead of asking artificial intelligence to generate legal documents, we may ask it to model legal reasoning itself. Given a factual event, E, an AI system could generate a large set of candidate legal programs. P equal to P1, P2, P3, Pn. Each program could then be evaluated independently. For every program, the system could estimate interpretive competence, legal valence, evidential sufficiency, procedural compatibility, available remedies, jurisdictional suitability, litigation risk, strategic coherence, interaction with competing legal programs. The result would not be a single legal answer. It would be a computational map of the legal landscape surrounding the event. The system would identify which programs produce meaningful legal interpretation, which produce no legal valence, which are internally inconsistent, which depend upon facts that cannot realistically be proved, which are likely to be displaced by competing programs. Artificial intelligence therefore ceases to function merely as a drafting assistant. It becomes a computational architecture for exploring legal possibility. This changes the role of AI fundamentally. Rather than replacing legal reasoning, AI expands the space within which legal reasoning can occur. The lawyer remains responsible for legal judgment. The lawyer remains responsible for ethics, strategy, professional responsibility, and the final selection of legal arguments. Artificial intelligence performs a different task. It performs large-scale program simulation beyond ordinary human cognitive capacity. A human lawyer can usually compare a small number of legal programs. An AI system can compare hundreds or thousands simultaneously. It can identify hidden legal pathways. It can detect conflicts between programs. It can identify assumptions imported from one program into another. It can test the stability of a legal strategy under multiple alternative interpretations. Most importantly, it can repeatedly return every competing program to the zero state and ask the same foundational question. Does this program possess interpretive competence over the legal question being asked? If the answer is no, the program returns L equal to 0. The computational search continues. This approach transforms the role of AI from document generation to legal cognition. Its purpose is not to write legal arguments. Its purpose is to calculate the architecture within which legal arguments become possible. This is what the present paper calls legal program simulation. Viewed in this way, artificial intelligence is not primarily a tool for automating legal practice. It is a tool for exploring the computational structure of law itself. #11. towards a computational definition of legal intelligence. The preceding sections introduce the principal variables of the model: the factual event, E, the legal program, P, the legal interpretation, I, the legal valence, L, the judicial function, J. Taken individually, each variable describes only one aspect of legal reasoning. Taken together, they describe a computational architecture through which reality becomes law. The complete interpretive sequence may therefore be expressed as follows. First, a factual event exists independently of legal reasoning. E. The event is then processed through a selected legal program. I equal to FP, E. The interpretation generated by that program produces legal valence. L equal to G, I. Competing parties generate competing interpretive systems. Claimant: EC, PC, IC, LC. Defendant: ED, PD, ID, LD. The judicial function evaluates the competing systems rather than the event in isolation. Decision equal to J, EC, PC, IC, LC, ED, PD, ID, LD. The complete computational architecture of legal reasoning can therefore be represented as reality, event, E, selection of legal program, P, legal interpretation, I, legal valence, L, judicial evaluation, J, legal decision. This sequence suggests a broader definition of legal intelligence. Legal intelligence is not the ability to retrieve legal rules, nor is it the ability to generate legal documents. It is the ability to identify, construct, compare, test, and maintain competing legal programs capable of transforming factual reality into legally meaningful interpretation. More formally, Li equal to phi E Pi Lj, where legal intelligence represents the capability to optimize the entire computational process rather than any single stage within it. In practical terms, legal intelligence consists of 5 cognitive operations. 1. Identifying the factual event without premature legal classification. 2. Selecting or constructing legal programs possessing interpretive competence. 3. Generating coherent legal interpretations. 4. Evaluating the legal valence produced by each interpretation. 5. Comparing competing legal architectures through judicial reasoning. This model also explains why legal expertise cannot be reduced to knowledge of statutes, precedents, or procedural rules. Those materials operate inside an already selected legal program. The primary intellectual task occurs one computational layer earlier. It consists of determining which program should exist before legal reasoning properly begins. This is the central proposition of the present paper. Law does not begin with legal rules, it begins with program selection. Everything that follows, interpretation, legal valence, judicial evaluation, and legal decision, is a consequence of that initial architectural choice. Conclusion. For centuries, legal reasoning has been described as the application of law to facts. This paper suggests a different sequence. Facts do not speak to law directly. A factual event first enters a field of possible legal programs. Most of those programs return 0 because they have no interpretive competence over the event. A small number are capable of transforming the event into a legal interpretation. That interpretation then generates legal valence. Only after this sequence has occurred can the legal system assign the familiar binary marks of lawful or unlawful. The binary code is therefore not rejected. It is relocated. Legal-illegal is not the beginning of legal reasoning. It is its final compression. The deeper architecture is event, legal program, legal interpretation, legal valence, judicial function, decision. If this model is correct, the future of legal AI does not lie primarily in document generation. It lies in program simulation. AI becomes valuable not because it can draft faster, but because it can explore the space of possible legal programs more widely than any individual human lawyer could do alone. And legal intelligence begins not with the answer, but with the architecture through which reality becomes capable of receiving one.